All right, good morning, everyone. I'm Judge Jackie Powell. We're here this morning in its first appearance court. Today, we're going to talk about finding of probable cause, and then we'll talk about release conditions. Today is not your trial date, so I encourage you this morning not to talk about your case because everything in this courtroom is being recorded. If you are represented by an attorney from the Public Defender's Office, you may want to speak with your attorney before saying anything on the record. If you have a private attorney, they usually come to the courtroom, and they can also speak on your behalf. So please keep that in mind. When I call you up, I'm going to ask you to come to the podium, and then we will address each person individually. There are two persons that the jail has asked me to call out of turn. So let's start with those two. There is Tevin Dean on page 17.
Good morning, Judge. He's approaching.
All right, Mr. Dean, you are before the court. Count one is robbery with a firearm, and count two is wearing a mask while committing a third-degree felony. The court does find probable cause, and I'll hear from the attorneys in regards to bond.
Your Honor, the state would be seeking a no bond hold upon a finding of proof evident or presumption great for first appearance purposes. While conducting surveillance on Mr. Dean and his co-arrestee, Mr. McDowell, for committing similar offenses, law enforcement literally caught Mr. Dean committing this act, this robbery firearm, at this Walgreens. He was found in possession of the firearm, still wearing the mask, and had the money that was stolen from the Walgreens. I would note that both Mr. Dean and Mr. McDowell made video recorded post-Miranda confessions.
Okay. Good morning, Ms. Chase.
Good morning, Judge. With respect to Mr. Dean, we're just going to ask that the court not make a finding of proof evident presumption great at this time based on the fact that what we have is a page and a half of a probable cause affidavit at best, and being a proof evident presumption great is the highest standard that we have. I'd ask the court not to make that finding today.
Having reviewed the probable cause affidavit, it is alleged that Mr. Dean was caught just minutes after this incident occurred. That the police officers who wrote this probable cause affidavit did make those observations. And based on that, the court this morning will, as to count one, will make a preliminary finding of proof evident presumption great. This is without prejudice for the defendant to have a bond hearing based on State v. Author. The defendant will be held no bond as to count one. Does anyone wish to be heard as to count two?
Nothing from the state, Judge.
Okay. And as to count two, the standard bond of $3,500 is in place. Okay. All right. Cody Syker.
He's approaching, Judge. He's here at Maine.
Was this one we made probable cause finding yesterday, or?
How do you spell his last name? How do you spell his last name?
All right, sir, you are before the court. I think, I'm not sure, so we'll do this again, because it looks like we did make a probable cause finding yesterday because of the several medical resets. But you are before the court this morning for possession of methamphetamine Count 2 is disobeying a red light, and count 3 is a vehicle without lights at night. The court does find probable cause. And does the parties wish to be heard as to bond?
Not at this time, Judge.
Okay. All right, sir, your bond is $1,000. Good luck. All right, and then one more sign in on page 10, Jacob Baisley, Attorney Presser. Good morning.
Mr. Bates, come on up. There's your private attorney.
For the record, Shlomi Presser on behalf of Mr. Baisley. Good morning, Judge.
Good morning. Have you had an opportunity to speak with the state? Is there anything?
I have, Your Honor, I think there's a,
Close, we just couldn't exactly.
we're correct. We've tried to hammer out the issue with bond. I think we're a little bit off in terms of where we're hoping the court would set bond. As to PC, Judge, I'm not gonna argue that. I'll say that there is PC.
Okay, so Mr. Baisley, you are before the court this morning for aggravated battery on a pregnant person. And so the court does find probable cause, and then now I'll hear from your attorney as to bond.
Thank you, Judge. I think the state, Mr. Linder and I spoke, the state was gonna ask the court for a $10,000 bond. I was gonna ask for half of that, for a $5,000 bond. Before this court is a young man who's got, as far as I'm aware, and I asked Mr. Linder, I think he confirmed this, got no prior criminal history. Although he is a resident of the state of Ohio, I can assure the court he's going to appear at all future hearings. He's not a flight risk. The proof that I'm standing here before you this morning shows that he is here to answer to his charges. I think a $5,000 bond would be sufficient to assure his future appearance in court. Obviously, we don't have any concerns where we're entering contact with each other and things of that nature is typical in the domestic violence world. I suspect there's going to be a self-defense argument in just the conversation I had with his family over the, actually late last night, but again, I don't have anything other than this PC to go through, so therefore I'm asking for a $5,000 bond, he said.
Your Honor, it is true Mr. Baisley has no criminal history. That being said, I spoke directly with the alleged victim this morning. She is in fear. She has suffered bruising, from what she told me, significant bruising to her face. I am
Hold
gonna-
on a minute, Mr. Linder.
Thank you.
Main jail, can you please turn the microphones off? Thank you. When we figure out how to get this, so, I'm sorry, Mr. Linder.
that's okay.
Sometimes I try to listen without having to tell them, but, after a while, it's like, I can't hear anything.
I can certainly understand that. So yeah, I am gonna be requesting a $10,000 bond, Your Honor, also noting while Mr. Baisley does have local counsel and family here, he does reside in the state of Ohio, and I do consider the victim's physical condition to be an aggravating factor.
Okay? And you said he has family who lives here
He's got
locally?
family in Miami-Dade County, Your Honor. That's actually who I've spoken to and who's retained me. His wife is actually going to be landing in Fort Lauderdale any minute now. He's got a wife and children back home in Ohio, but he does have local family here as well in South Florida.
All right. I am going to impose a $7,500 bond. And no victim contact.
Thank you, Your Honor. Have a good morning, Judge.
You too, thanks. All right. All right, Mr. Shade, ooh. Yeah. All right, Mr. Romero, I guess I'll give you time to speak to some other folks. Mr. Shade does have a few here. So, let's start with Susan Budlong Rogers on page 2.
Got that green shirt still going with the Easter.
There's,
So just matters out of the city of Hollywood. They've offered Miss Budline Rogers a time served.
All right, Ms. Rogers,
Yes, ma'am.
I'm going to tell you what's been said. You are before the court today for a misdemeanor capias. You did not show up for arraignment on a sleeping on, city-owned property charge from August of last year, August 2018.
Yes, ma'am.
All right, so your attorney this morning, who has received an offer from the city prosecutor, and their offer is adjudication and time served. Do you understand that,
Okay.
ma'am?
For the time since yesterday when I got here?
Yes.
Okay. I was waiting for the gentleman to come out of the church. The officer had seen me.
Okay,
was-
don't talk about your case because
Okay.
I don't know what you're going to do yet. So with that offer, do you wish to resolve your case today?
Yes, that's fine.
All right. So,
I had already walked to the courthouse before this warrant.
Okay.
That when the day that he told me to report to the courthouse, I had walked to the courthouse.
okay.
So
All right. So ma'am, if you
That's-
wish,
that's fine.
okay, if you wish to resolve your case today, then there's just a few questions I have to ask you to make sure that that's what you wish to do, and I have to ask you those questions under oath. So I'm going to ask you to raise your right hand as best as you can. Do you swear or affirm to tell the truth?
yes,
All right, you can put your hand down. All right, Ms. Rogers, is anyone forcing you to resolve your case today?
no,
Do you need any more time to speak with your attorney? He's standing right there in front of the screen. He's on the screen. If you look at the screen,
Oh, well, the only reason I was,
Ma'am, don't
I
talk
just
about the
wanted
fact,
to make
ma'am,
the
don't
point
talk
clear.
about the facts of the case. Ma'am, please
reason
don't
I
talk
was-
about the facts of the case. Do you
Well,
have any-
then-
Ma'am, please don't talk about the facts of the case. Do you have any questions for me?
okay, no, I don't have any more questions.
are you sure? 'Cause
Yes.
Okay. All right. Do you understand? You have the right to go to trial, but by taking a plea today, you are giving up that right.
I understand.
All right? Have you ever been treated for mental or emotional illness?
Yes, back in the 80s.
Is there anything about that illness today that would prevent you from making an intelligent decision?
No,
All right. Do you understand that if you're not a U.S. citizen, that by taking a plea today, it could subject you to deportation or immigration changes?
I am a U.S. citizen.
Okay.
I was,
All right.
understand.
That's fine. These are just questions that I am required to ask you, so
I
that's
understand.
okay. All right. So with that said, what plea do you wish to enter? Guilty or no contest?
No contest.
All right,
because-
I accept your no contest plea. I find that it's freely and voluntarily given, and your sentence will be adjudication and time served. I will give you 6 months to pay your court costs. Okay?
Pardon? I didn't hear it. The speaker broke up. How many?
6 months to pay your court
Oh, okay.
costs. Okay?
And what is that?
This is it
$78.
$78? It's $78.
Okay, thank you.
All right, good luck, ma'am.
Thank you.
John Noland on page 12.
She's a content.
Nolan,
I'm sorry?
Conti, Your Honor?
All right, Mr. Noland, you are before the court today. It's an add charge. This is now charge number 7 for trespassing.
Yes, ma'am.
I'm sorry? All right, okay, so, Mr. Nolan, apparently this CAPIA should not have been issued. Well, you were in custody at the time.
Yes, ma'am.
Is there anything else that's holding you in custody?
Yeah, but I guess I
He's
got,
also on the second look docket in the afternoon, so I don't know if it's the same, I don't know if it's the same thing.
Okay,
So for Mr. Nolan, it'd be time served, but
No
I'm
bond
not sure
holds?
when or what that other felony charge is. So I'd rather us go to the division.
Hold on a second.
okay, all right, so Mr. Noland, well, I don't know why he's on the second look docket. Is it for a 30-day motion?
That's what I'm
yes,
checking.
ma'am.
That's what I'm checking right now.
Judge, if that's the case, I'd ask that this be ROR so he can get out to.
It would appear so. Yes, that's what he's on the, for a motion to release.
Do we know, is it something we can address this morning? Can we figure out if the information's been filed? But he has no bond holds on other things.
No, just that.
Oh, just that? Oh,
Yes, it does not appear that it's gonna be filed by, this afternoon.
all right. Ms. Shirley, if we give you, this, Mr. Noland is on the afternoon docket for a 30-day motion. If we give you the case number, this information has not been filed, so can we address that this morning? Yes. All right. Okay. All right, Mr. Linder, can you give us the case number?
Of course, 193788 CF10A with charges of possession of cocaine, cannabis 20 grams or less, and drug paraphernalia.
This says charge 7. Are there other things, or did
One
he
through
resolve?
three, one and two are no info. 3 was a traffic infraction. 4 through 6 is the 30-day case, and this is 7.
Okay. All right, so Mr. Noland, you have this ad charge today. It's a municipal ordinance violation for trespassing, okay?
Yes.
All right, and so I find probable cause on this new charge. You have several other, charges under case number 193788 CF10A, which you were scheduled to be before me this afternoon for a 30-day motion for release, okay?
Yes, ma'am.
And so that we don't have to bring you back again this afternoon, the state has checked and they have not filed the information. So you are entitled to be released on your own recognizance at this time on that charge. Sir,
Okay, thank you.
it does not mean that the state is never gonna file the charges. It's just, okay, just means that they can't hold you in custody any longer until they file it. So you are
Yes.
going to need to pay attention
Keep
to your
tab.
mail
Yeah.
and check and make sure to determine whether or not you have to come back to court, okay?
Yes, ma'am.
All right.
Yes, ma'am.
Mr.
And-
Nolan, do you have a good address?
64.
Well, you don't have to
Fletcher
give it,
Street.
but is it the proper address? You
Yes.
received mail there? Okay,
Yeah.
thank you.
And then as to this new charge, then I'll ROR him on this as well, okay? All right, good luck, sir.
Thank you, ma'am.
On page 12, Matthew Inverso.
Good morning.
Good morning, Mr. Inverso. You're before the court on you did not show for arraignment on April 10th, 2019 on an alcoholic beverage violation charge. And so that's why you're before the court today, because you missed court. So, what do you wish to do today, sir?
Judge, it'd be a time served offer from the city of Fort Lauderdale.
All right?
I would like to resolve it.
All right. The city of Fort Lauderdale's offer is adjudication and time served. Would you like to accept that offer?
Yes, ma'am.
All right, as best you can, please raise your right hand. Do you swear or affirm to tell the truth?
Absolutely, yes.
Okay, you can put your hand down. Mr. Inverso, do you understand everything that's going on here today?
Yes, ma'am.
Are you under the influence of drugs or alcohol?
No, ma'am.
Is anyone forcing you to resolve your case?
No, ma'am.
Do you need more time to speak with your attorney?
No.
And you understand you have the right to go to trial, but by taking a plea today, you're giving up that right?
Okay.
Have you ever been treated for mental or emotional illness?
No.
And do you understand that if you're not a U.S. citizen, by taking a plea, it could subject you to deportation or immigration changes?
Yes, ma'am.
Okay, Mr. Inversa, what plea do you wish to enter? Guilty or no contest?
No contest.
All right, I accept your no contest plea. Find that it's freely and voluntarily given. Your sentence, sir, is adjudication and time served. I'll give you 6 months to pay your court costs. Good luck.
Thank you, ma'am.
Also on page 12, Aldwin McLaughlin.
No problem, Your Honor. Good morning.
Good morning.
Outside. Oh,
Good morning, sir. You are before the court because a capias was issued on January 31 of this year on a trespassing charge. And the court does find probable cause. What does Mr. McLaughlin wish to do?
Judge, it would be a time served offer.
All right, sir, if you,
Could I say something? I would like to say, when was that trespassing charge and where was it at?
State, if you could help Mr. McLaughlin with this,
Just need a case number.
18004538 MO40A.
September 1.
October 3rd, 2018 at 1723 East Young Circle in Hollywood.
Okay? There's information,
So-
sir, it's from October.
It's a
Okay?
Walgreens.
At Walgreens, at Young Circle.
I saw them. Let's go.
All right, so the offer to resolve the case is adjudication and time served. Do you wish to resolve the case with that offer?
How long is that?
Get out this afternoon.
Get out this out.
All right, thanks.
All right, sir, please raise your right hand. As best you can, do you swear or affirm to tell the truth?
Yeah,
All right, you can put your hand down. Do you understand everything that's going on here today?
yeah,
All your questions have been answered?
yeah.
Do you need any more time to speak with your attorney?
Nope,
Are you under the influence of drugs or alcohol?
not at this moment.
Is anyone forcing you to resolve your case?
Uh-huh.
Do you understand that you have a right to go to trial, but by taking a plea today, you are giving up that right?
Yeah.
Have you ever been treated for mental or emotional illness?
Yep.
Is there anything about that illness today that would prevent you from making an intelligent decision?
Nope.
And do you understand that if you're not a U.S. citizen, by taking a plea today, it could subject you to deportation or immigration changes?
Yep.
What plea do you wish to enter? Guilty or no contest?
Not guilty.
No, it's got to be either guilty or no contest.
Oh, okay.
Guilty, okay. I accept your plea and I find that it's freely and voluntarily given and your sentence is adjudication and time served. Good luck, sir. All right, Robert Brisbois on page 12.
Yeah, he's got a state case too.
Is this at the city of Fort Lauderdale?
It's actually Hollywood, Judge.
Oh, it's Hollywood?
And I believe count one is a state offense, Judge.
Okay. All right, Mr. Brisbois.
Good morning.
Good morning. You shouldn't be here today, right?
Excuse me?
You shouldn't be here today.
I don't have much choice, ma'am.
Oh, you know, from our last conversation, last time I saw you, you shouldn't be here today. That's what I'm talking about.
Well, I'm adding up the days.
You're heading up to where?
I'm adding up the days. I've got a lot of days in on this trespassing charge.
Oh, you're adding up the days. Well, the last time I saw you, you know, you were going to be fighting this and you were going to file
They
charges.
sent me the warrant before they sent me the court date.
But
I have a mailing address, and my brother brought me the warrant Sunday, and he brought me the warrant, and I never got a court date.
Okay, but you know, it's your responsibility to check and make sure, not your brother's. So if you know,
Well,
right?
I don't have a telephone anymore, and I don't have a computer or any of that garbage, and I'm homeless, and makes it difficult to get the telephone.
I hear you. All right, so
And
today,
Judge, that's what Mr. Breesbo advised me. He advised me that he wishes to fight these allegations, and he advised me that it wasn't a voluntary decision in which he missed court. It was because of the circumstance he just stated to the court. So Judge, Mr. Breesbo is requesting the court release him ROR.
Is that just on yours, or is that also on?
Oh, I only spoke to him about the trespass, Mr. Shane.
well, you know, Mr. Breezeball has been here several times, and we've had this conversation.
Judge Carpenter Toy just ROR'd him on March 29th.
Yeah.
He filed a notice of change of address. I mean,
Yeah. So, you know, there's always one reason or the other, but Mr. Brisbane, after a while, you know, we can't just keep RORing you and having you to come back again. Plus, I heard that your division judge also recently ROR'd you. So I'm not going to do that today. So your bond is in place, unless you tell me something otherwise. And you don't even have to make a decision today because you do have court tomorrow before your division judge. So we can do that. All right, so we'll just leave it. You have court tomorrow with your division judge. All right?
Yep, tomorrow, sir.
I got court tomorrow?
Yes.
At 9 a.m.
All right, good luck, sir. Timothy Kylo on page 13.
Mr. Kylo, come on up, please.
Come on out.
This is a Deerfield Beach, they've offered time served. Doesn't have the balance.
All right, Mr. Kylo, you have a CAPIS on a municipal ordinance violation, and the city is offering you adjudication and time served. Do you wish to accept that offer to resolve your case, sir?
Yes, ma'am.
All right. Mr. Kylo, please raise your right hand as best as you can. Do you swear or affirm to tell the truth?
Yes, ma'am.
Okay, you can put your hand down. Mr. Kylo, you understand everything that's going on here today?
Yes, ma'am.
Is anyone forcing you to resolve your case?
No.
Are you under the influence of drugs or alcohol?
No, ma'am.
And do you understand that you have a right to go to trial, but by taking a plea today, you are giving up that right?
Yes, ma'am, I understand.
And do you understand that if you're not a U.S. citizen, by taking a plea, it could subject you to deportation or immigration changes?
Yes, Your Honor, I understand.
What plea do you wish to enter, Mr. Kylo?
No contest.
I accept your no contest plea, find that it's freely and voluntarily given, and your sentence, sir, is adjudication and time served. Good luck.
Okay, thank you, ma'am.
Kevin Byrne on page 13.
Good morning.
Good morning, Mr. Byrne. You are also before the court on a municipal ordinance violation for solicitation, and it looks like you did not appear. No, this is a new law violation. So the court does find probable cause, Mr. Byrne. What do you wish to do?
Judge, the city promptly obeyed.
Resolve it.
They would offer him time served and just remind Mr. Byrne that he has to stop doing this.
Yes, ma'am.
It's getting close to where they're not gonna just pay you out to time served, Kevin.
Thank you.
All right, so Mr. Byrne, you've heard that, and you probably heard me talk to other persons before you that you have to make a change, right?
Yeah, I'm ready to leave. I'm ready to leave Pompano.
You've got to make the adjustment because the officers are,
Yeah.
if you're in violation, they're gonna
It's
pick you
getting
up.
out of control.
Okay.
You're right.
So, you wish to resolve your case with the adjudication and time served?
Yes, ma'am.
All right, sir, please raise your right hand. Do you swear or affirm to tell the truth?
Yes, ma'am.
All right, you can put your hand down. Mr. Byrne, you understand everything that's going on here today?
Yes, ma'am.
Is anyone forcing you to resolve your case?
No, ma'am.
Are you under the influence of drugs or alcohol?
No, ma'am.
And you understand that you do have the right to go to trial, but by taking a plea today, you're giving up that right.
Yes, ma'am.
And you understand that if you're not a U.S. citizen, that by taking a plea today, it could subject you to deportation or immigration changes.
Yes, ma'am.
All right, what plea do you wish to enter, Mr. Byrne? Guilty or no contest?
No contest.
I accept your no contest plea. I find that it's freely and voluntarily given. Your sentence is adjudication and time served. Good luck, sir.
Thank you.
All right, on page 14, Robert Morehouse.
Good morning.
Mr. Morehouse, you are before the court today for a municipal ordinance violation. The court does find probable cause. What's the deal? All right, Mr. Morehouse, the city is offering adjudication and time served to resolve your case. Do you wish to accept that offer?
Yes.
All right, please raise your right hand as best you can. Do you swear or affirm to tell the truth?
Yes.
Okay, you can put your hand down. Do you understand everything that's going on here today?
I do.
And do you need any more time to speak with your attorney?
No.
Are you under the influence of drugs or alcohol?
I'm not.
You understand you have the right to go to trial, but by taking a plea today, you're giving up that right?
I do.
And do you understand that if you're not a U.S. citizen, by taking a plea today could subject you to deportation or immigration changes?
I do.
What plea do you wish to enter?
No contest.
I accept your no contest plea. Your sentence is adjudication and time served. Good luck, sir.
Thank you.
On page 14, Tendai Morape. Mr. Morape, you're before the court for a municipal ordinance violation. The court does find probable cause.
They would offer time served.
Mr. Morape, I've had this conversation with you also before. And it's incumbent on you to make a change, sir, so that you're not before the court all the time on these municipal ordinance violations. So you've got to do something different, right?
Yes, ma'am.
All right, you don't want to keep doing the same thing over and over and keep coming back for the same thing over and over. It really doesn't help you, right?
Yes.
All right, so today the city is extending an offer of adjudication and time served Do you wish to accept that offer to resolve the case today?
Yes.
All right, so raise your right hand as best as you can. Do you swear or affirm to tell the truth?
Yes.
You can put your hand down. Do you understand everything that's going on here today?
Yes.
Is anyone forcing you to resolve your case?
No.
Are you under the influence of drugs or alcohol?
No.
Have you ever been treated for mental or emotional illness?
No.
And do you understand that if you're not a U.S. citizen, by taking a plea today, it could subject you to deportation or immigration changes?
Yes.
What plea do you wish to enter, sir?
No contest.
All right, I accept your no contest plea. Find that it's freely and voluntarily given. Your sentence is adjudication and time served. And Mr. Marape, can I say it one more time? Do not go back to this location. Do you understand that, sir?
Yes, yes.
All right.
Thank you.
You're welcome. Charles Sinclair on page 14.
Good morning, Your Honor.
Good morning, Mr. Sinclair. You are before the court on a municipal ordinance violation. The capias was issued March 22 of this year because you did not show up for arraignment, sir.
Yes, ma'am.
So I find probable cause, and what do you wish to do today, sir?
Judge, the city has a time served.
Resolve it, ma'am.
Okay,
Can I?
is it a time served offer?
Yes,
Yes,
ma'am.
Judge.
Yes,
All right.
ma'am.
All right. So, Mr. Sinclair,
Yes, ma'am.
I'm sure you've heard me talk to the other gentleman who came before you, and
Yes.
so I'm gonna tell you the same thing. You have to do something different. You can't keep getting arrested at the same place for the same thing over and over again. Doesn't make sense, does it?
No, ma'am.
All right. So it means that you're gonna have to make a change, and you're gonna have to start with not going back to this place.
Yes, ma'am.
All right. So please raise your right hand as best as you can. Do you swear or affirm to tell the truth?
Yes, ma'am.
All right, you can put your hand down. And Mr. Sinclair, do you understand everything that's going on here today?
Yes.
Is anyone forcing you to resolve your case?
No, ma'am.
Are you under the influence of drugs or alcohol?
No.
And have you ever been treated for a mental or emotional illness?
No, ma'am.
And do you understand that if you're not a U.S. citizen, by taking a plea today, it could subject you to deportation or immigration changes?
Yes, ma'am.
Okay, what plea do you wish to enter, sir?
No contest.
I accept your no contest plea, find that it's freely and voluntarily given. Your sentence is adjudication and time served. And with one more reminder, do not go back to this place. Do you understand that?
ma'am.
Okay.
Yes. All right, thank you.
All right, Vernon Keat.
Medical reset, Your Honor.
All right.
Medical reset.
Again, thank you, Judge. Have a great
All
day.
right, Mr. Shade, see you. All right, let's go back to the top and call some from the regular docket. So Yvette Jean.
Anna, we do have family present, and grandparents.
All right. Good morning, folks. All right. All right, Miss Jean, you are before the court today for 2 counts of aggravated battery with a deadly weapon. And the court does find probable cause. And I see we have some lovely people in the courtroom this morning, I guess on your behalf. So we'll hear from the parties in regards to setting the bond.
Your Honor, Yvette has been in my granddaughter. She's been in my life since she was born. She's a good girl. She's still in high school. She's getting ready to graduate and go in the Navy. She works after school, trying to help herself get prepared for her graduation. And she comes over. She lives with her dad, but I would love for her to come stay with me.
Okay.
I would love, because I know that she's never been in trouble. Never. That's the first time she ever sat in a police car.
Okay.
And me and my husband, he's a veteran, Vietnam veteran, and I'm a nurse, a retired RN. And I worked 38 years, and I took care of her as well. And I just saw her yesterday. She was just at the house.
Okay.
And I know she's a sweet person. Never been in no trouble. And she was getting prepared to, she got this job. She loved to work. And she working. She's supposed to be in school today. But all that happened. But I do know she's a very, never talk back to you. I've gotten on her, and she never said a word. She'll come in and say, Grandma, I'll wash the dishes. Grandma, Grandpa,
Schedule
just as sweet as she can be.
to level.
And she love her dad, because
Okay.
her dad is kind of sick too, and she worries about him, and she brings his clothes in my house and wash them, and she's just a very pleasant child who was just pushed up against the wall.
Okay, ma'am. Thank you for being here. It's never, this is never the way we want to meet. I know that these circumstances are not easy, but thank you for coming in and sharing what you have or adding what you have to this. I'll have to hear from the state now as well, so,
Judge, if I may too,
And-
I just wanted to point out, I did speak to them prior to court.
yes.
And in terms of, I know she mentioned that that she lives with her father, but they had advised me she can live with them. So
Okay.
the no contact order wouldn't be an issue.
Okay, thank you.
Yes, and they were prepared to try to help, but they're on a fixed income when it comes to any type of bond.
Okay.
Your Honor, while it is true Ms. Jean has no criminal history, and I certainly understand that there are financial restraints, I am very concerned about the level of violence alleged in this report. And Ms. Jean allegedly stabbed her stepmother in the stomach multiple times, used a stun gun against the victim in her head and neck area. This was corroborated by an independent witness. I know Ms. Jean claims it was self-defense. The problem with that is, according to Ms. Jean, additionally, when the victim tried running away from her, she chased her, continued following her, kicking her vehicle, and attempted to continue attacking the victim. And that just wouldn't go hand in hand with someone that is supposedly in fear and only acting in self-defense. I'm going to be requesting a $25,000 bond on each count, no victim contact, pretrial release with a GPS monitor.
Okay,
Judge, as you heard from Ms. Jean's grandmother, that's something simply that the family doesn't have. Their financial resources are quite limited, so $50,000 would basically be something impossible for them. As you heard, Judge, she has a clean record. As you heard from the grandmother, this is something very out of character for Ms. Jean. And I've spoke to Ms. Jean, and she is looking forward to her day in court. And as Mr. Lender alluded, basically this is going to be self-defense, in which hopefully in the future the facts will be brought out that basically she was attacked first. Now, Mr. Lender categorizes the witness as independent. That independent witness happens to be best friends with the sort of stepmother, and basically corroborated the stepmother's story to the police. Having said that, Judge, she's 18 years old. She's been here her whole entire life. She goes to school. She goes to Coconut Creek High School, where she is a senior, and she's going to graduate this year. She's already taken the SATs. She has a 2.5 GPA, and she already has her plans to attend ATC, where she wants to be a dental assistant. Now, she did already speak to her father, and I believe she already spoke to her grandmother and already made arrangements, and she's going to be living with her grandmother and basically have no sort of contact with the alleged victim, and she will be abiding by that. She will be coming to all her court dates, and as you heard, besides being a full-time student, what she does is she also works part-time. She works at McDonald's. She goes there after school on Mondays and Wednesdays and on the weekends. Judge, this is a person that very much, I have no inclination that she'll be a flight risk at all. Judge, I'm just simply asking at this court, I understand the allegations are serious. I'm going to be requesting a $2,500 bond on count 1 and on count 2. And along with that, I'm going to be asking for supervision. So, Judge, at this time, we're asking for a total $5,000 bonds and place Ms. G on supervision.
All right, thank you, everyone, and these are serious allegations. And, you know, again, I know that you're here for support, but for today, I have this to make a determination based on probable cause, to determine probable cause, and based on the affidavit that I have, like I said, the allegations are serious. Today is not the trial, and so I know you've heard the attorney talk about self-defense. There is going to be another time and place for those motions, for those arguments to be made. Today's not the day. She'll be assigned to a division judge, and those motions and different, whatever motions that her attorney has will be filed before that judge, and that judge will hear the case up till trial, okay? So today is, just as it says, it's the first appearance court. And so, based on the allegation that has been presented to me today, I do make a finding of probable cause. I am going to impose a bond of $10,000 on each count, so it'll be $20,000. That's not the option, that's not what I'm going to do today, sir, okay? I have to take everything into consideration today. So it'll be 10,000 on each count, and there'll be no victim contact until further order of the court, okay? All right, thank you and good luck. We have the Spanish interpreter. Do we know who needs a Spanish interpreter?
Para?
Judge, on page 13, Mr. Santiago Parra would require a Spanish interpreter, but that's all I found out for right now.
Okay,
Anyone in back? Anyone in back Spanish? Or no? We don't know? Okay, so just, okay.
Senor Para.
all right. Good morning.
Good morning, Your Honor. How are you?
Is there affirmed to translate from Spanish to English and English to Spanish?
I do, Your Honor. Gabriel Sinisi, court interpreter.
All right, Mr. Parra,
Señor Parra,
you are before the court today
está ante el tribunal esta mañana
on 3 traffic capias matters.
por 3 casos de tráfico con orden de arresto,
Operating without a valid license.
operando sin licencia válida.
This capias was issued November 7th, 2017.
Esta orden de arresto fue emitida el 7 de noviembre de 2017.
And then another count of operating without a valid license.
Otro cargo de operar sin licencia válida.
This capias was issued October 3rd, 2017.
Esta orden de arresto fue emitida el 3 de octubre del 2017.
And the third is operating without a valid license.
Y el tercero es operar sin licencia válida
And this capias, you failed to show for arraignment
y no compareció para su audiencia de instrucción de cargos
on October 11th, 2017.
el 11 de octubre del 2017.
Okay, so what does Mr. Para wish to do?
¿Qué desea hacer el señor Parra?
Judge, at this time, nothing to add. He gave me the phone number of his brother. I'm going to be contacting him after court.
En
Okay,
este momento nada que agregar, su señoría. Voy a contactar a su hermano para cumplir con la fianza.
all right, so the bonds are $500, $1,000, and then $250.
Así que las fianzas son $500, $1,000 y $250.
All right, good luck, sir.
Suerte, señor.
All right, at any of the other facilities, North Broward, Conti, or Paul Ryan, do we need a Spanish interpreter?
Orion, no, Your Honor.
All right, thank you. Hearing nothing, Mr. Sinisi, thank you.
You're welcome, ma'am.
All right. All right, Kim Dale. Kim Michelle Dale.
She's approaching, Judge. She's here at me. Ms. Dale, come on up, please.
All right, Ms. Dale, you're before the court on a misdemeanor capias on a driving while license suspended. This capias was issued April 17th of 2018. The court does find probable cause. What does Ms. Dale wish to do?
Judge, in speaking earlier with Ms. Dale, she wishes to ask the court will consider resolving this matter today.
All right. State if you have an offer.
Yes, Judge. The offer is adjudication, time served.
Okay.
Judge, she wishes to accept the state's offer.
All right, Ms. Dale, please raise your right hand. Do you swear or affirm to tell the truth?
Yes, ma'am.
All right, you can put your hand down. Do you understand everything that's going on here today?
Yes, ma'am.
Is anyone forcing you to resolve your case?
No, ma'am.
Do you need any more time to speak with the attorney?
No, ma'am.
Are you under the influence of drugs or alcohol?
No, ma'am.
Have you ever been treated for mental or emotional illness?
No, ma'am.
And do you understand that if you're not a U.S. citizen, by taking a plea today, it could subject you to deportation or immigration changes?
Yes, ma'am, I do.
Okay, what plea do you wish to enter, Ms. Dale?
No contents.
I accept your no contest plea. I find that it's freely and voluntarily given, and your sentence is adjudication and time served. Good luck, ma'am.
Thank you.
All right. All right, all right, I have two persons who've signed in the courtroom. On page 14, Michael Cordova.
Mr. Cordova, come on up, please. This way.
Have you had an opportunity to speak with him, Mr.?
I have, Judge. Thank you very much for inquiring.
All right,
You have friends
Mr.
and family.
Cordova, you are before the court today for one count of petty theft. And the court does find probable cause. And I'll hear from the parties as to bond.
Judge, the only thing I'm going to be asking, I see he has friends in court. I just want to inquire if they're going to be able to post this $100 bond.
Good morning, folks.
Perfect. Then nothing to add from the defense.
Okay, all right. All right, so his bond is $100, okay? All right, good luck. James Monroe, on page 22. Is someone signed in for Mr. Monroe? Well,
No, I haven't spoken to him, Judge.
all right, then we'll recall it,
I think the
because
cutoff was.
whoever signed in is not
It
here.
was his father,
Oh.
and he had to leave because of a parking situation, so I did get information from him.
Okay, all right, when you're ready, okay. All right, I don't know what this is. Then on page 7, Alexandria Isaacs.
Medical loan, Judge?
Okay, good morning, ma'am, how are you? All right, are you related to Miss Isaacs? Okay, so she, has been on medical loan for the past couple days.
Medical
Loan.
what does that mean?
That means that, there is some medical issue that, I guess that they're taking care of, so she's not able to be before the court this morning. Okay? So you need to check with the jail so you can figure out, give them find out the information, but,
I've been trying to find out because the hospital hooked her on psychiatric medication, and she went last week to get treatment at Aventura, I dropped her off, the nurse told me she'll take care of her, and then they release her on the street. I file a missing report that, she was missing, and then the, Broward sheriff picked her up while she was walking and just delusional, and took her to Memorial Hospital. And that's where, he had an altercation with them while she was delusional, and she's not on her, medication. Because my daughter's a gifted child, and she never needed no psychiatric medication. And the hospital hooked her on the psychiatric medication for profit. Drug her, every month they keep on drugging her, and she don't need those drugs.
All
And
right,
those
ma'am,
drugs
I'm
cause
gonna,
them to rape her.
ma'am, I'm going to stop you right now, and I'm
Okay.
gonna tell you that it does sound like you have lots of issues that need to be addressed. This is not the forum for it. So if you need to find out more information about your daughter, you need to get in touch with the jail. I don't know if she's represented by the public defender's office. No, all right. Okay, so if she is, then maybe they can assist you, but you need to get in touch with the jail to find out more about how you
Saying
can
that
find
I
her.
cannot see her because she has a bond that not able for me to see.
Oh, she has no bond at this
No bond,
time
no
because
bond.
it's not a no bond hold, it's just that we haven't been able to have her here physically for her to be magistrated and for a bond to be set. All
Yes,
right?
Your Honor, but I haven't seen my daughter for almost 2 weeks, and I do not know what to do.
All right, ma'am. Okay.
Oh,
Good. All right?
Okay.
All right, good luck, ma'am.
Thank you.
All right, can we continue then with Chris Roddy? Bond was posted.
Judge, she's here, President.
All right, Ms. Roddy, you are before the court for DUI, alcohol or drugs, and DUI with a breath level greater than .15. I do find probable cause, and I've been advised that your bond has been posted. Good luck, ma'am. How about Maria Beaton?
Medical research, Your Honor.
Your Honor,
Yes.
I can advise the court that the mental health specialist at the jail this morning
Yes.
sent an email out to Judge Lerner Ren's JA referring Ms. Beaton to MI.
Okay, so, I'll make a finding of probable cause today, and then I'll also sign an order transferring to Judge Lerner Wren. You too, ma'am. All right, Shimona Bailey.
No grounds, Your Honor.
Good morning.
Good morning, Miss Bailey. You are before the court for one count of possession of cocaine. And the court does find probable cause. All right. Does anyone wish to be heard as to Miss Bailey's bond or release?
I speak with Miss Bailey. She's lived in South Florida, Broward County, her entire life. She resides with her mom, and she has 2 children. Her only source of income is disability. I don't believe she has significant prior history. I was going to ask the court to ROR her on this possession charge.
Okay.
Your Honor, she pled out a paraphernalia end of last year. She was arrested end of last year in a capias on a municipal ordinance as well. I'd be requesting pretrial with random testing.
All right, Ms. Bailey, I find probable cause. I will release you to pretrial supervision, and that's going to include random drug testing, ma'am. Okay? So the deputy's giving you that paper, which means that when you get out, you need to go to the pretrial supervision office and sign up. If you don't go there within 24 hours of your release, a warrant will be issued for your arrest. Okay? And then they'll give you further orders, they'll give you further instructions as far as the random drug testing.
Okay,
All right, good luck, ma'am.
thanks.
Lisa Ugaz. All right, Ms. Ugaz, you are before the court. Count one is possession of cocaine. Count two is possession of drug paraphernalia. Count three is felony violation of probation. That is a no bond hold, and you will be before your division judge tomorrow at 8:30. As to the other counts, I do find probable cause. And I will leave the standard bond in place, count one, $1,000. Good luck, ma'am.
Thank you. Come on.
All right, Dawn Powell.
Smoke, bro.
Good morning.
Good morning, ma'am. You are before the court on one count of making a false report of bomb explosive or bomb threat. And so the court does find probable cause. Does anyone wish to be heard as to her bond?
Judge, she has been a resident of Broward County for 3 years, and currently is living with her mom where she pays some rent. Her only income is disability. She does suffer mental health history. I was going to ask the court to release her to pretrial.
Okay.
State would oppose pretrial, Your Honor. I'd be requesting a $10,000 bond. No return or may not go on the property of University Pavilion Hospital unless she has official business there. No possession of any weapons, firearms, or explosive devices. 2015, she went through drug court on possession of diazepam, alprazolam, clonazepam.
All right.
I didn't know if Mr. Linder was finished. I just wanted to point out that 2015 case was some time ago. And speaking with her, and due to the fact that her only income is disability, which is a fixed income, I'd ask the court to, the 10,000, I think the state requested, is well beyond her means. If we could still supervise on pretrial, but lower that to something more close to what she could afford.
All right, there seems to be a lot of things going on here, even in this very short, probable cause affidavit, you can see that there are some things going on here. I do find probable cause. I am going to impose a bond of $5,000 with a level 2 GPS. Ms. Powell, you are not to return to this hospital, and no possession of any weapons or firearms. Okay, all right, good luck, ma'am.
Thank you.
All right, O'Reilly Colley.
She's here present, Judge.
Good morning, Your Honor, members of the courtroom.
Good morning. You are before the court today for count one is fraudulent use or possession of ID of another person without consent. Count two is driving while license suspended. Count three is an out-of-county felony hold, which is no bond and not for magistrate. And count four is a felony violation of probation that also has a no bond hold attached to it. The court does find probable cause.
Judge, as you can see, those out-of-county holds in the VOP on the felony offenses, they're from Dade County, in which they have a no bond hold. Considering on the new law offense that Ms. Colley has here in Broward County is not filed, it might take about 30 days to file it. Would the court consider an ROR on count one so that Dade County can pick her up.
Your Honor, state would object, considering the allegations are is that she used someone else's ID to avoid law enforcement from knowing her identity, presumably to avoid being picked up on the warrants, the violation of probation warrant. I do have concerns about her future appearance in court.
I am going to deny the ROR. The bond is $1,000 on count one. All right, all right, on, page 10, Mr. Raisman, Kwame Williamson.
Good morning, Judge. How are you today?
Mr. Williamson, come on up, please. Your private attorney's here. Look at the monitor, bottom middle, okay?
All right, Mr. Williamson, you are before the court today for one count of aggravated battery causing bodily harm. And the court does find probable cause. I'll hear from the parties.
Judge, Mr. Williamson has no prior criminal history whatsoever. He's a United States citizen. He goes to school and he also works. He was actually in the middle of taking up there at school for a final exam when he was taken into custody. He has another one tomorrow. I'm asking the court to consider a bond of anywhere between $2,500 to $5,000 to ensure his appearance in court. I don't think the state's going to argue that he's a flight risk. He's never missed any type of court appearance at all, and I would suggest that he's not a danger to the community. I understand, and he understands, he can have absolutely no contact whatsoever with the alleged victim. The firearm that he owns and has a concealed weapons permit for that was taken into custody on the property is already in the evidence of the police, and he understands he can have absolutely no contact with her whatsoever. As far as any danger to her, if the court is going to be considering any type of supervision by pretrial, I would respectfully request that you consider maybe a monitor with an open schedule. As I indicated, he does work as a driver and also as a full-time student, but that would ensure that he was not going to have any contact, unwanted contact, or any contact with her whatsoever without pretrial being notified to alleviate any concerns that he may be a danger to her in the future. He has no plans of having any continued contact with her. So respectfully requesting a bond. If you're going to consider pretrial, if you could would consider the lower end of what I'm requesting, the $2,500. If not, perhaps a higher bond. But it's the issue with the school and the work and the nature of his work that if you're considering pretrial, I would ask that you consider it the monitor with the open schedule.
Your Honor, the state is going to be requesting a $15,000 bond. Pretrial release with a GPS monitor. Obviously, no victim contact, no firearms or weapons. He does not have a criminal history. That being said, I am concerned about the allegations, Your Honor. The victim's physical injuries support her version of events. Our office had contact with the alleged victim. She advised our victim advocate she is terrified of Mr. Williamson. She also advised that he has threatened her with a firearm in the past. So that is why I'm requesting the bonding conditions that I've mentioned.
I would just like to suggest that no prior complaints by this particular witness have ever been brought forward to the state attorney's office before, so just in addition to what my previous arguments have been made.
And as the court and Mr. Reisman is well aware, in the realm of domestic violence, there are lots of incidents that never get reported to law enforcement. Your Honor, he's provided information that he's obtained from other sources. I'm providing information that, for bond purposes, not for probable cause, that the victim advised our office.
All right, thank you. I do find probable cause. I am going to impose a bond of $7,500 with a level 2 GPS. Sir, no victim contact. I'm sure you've heard your attorney explain what that means, and I'm sure he'll speak with you more about that, but no contact at all, no No text, no phone call, no social media, no asking somebody else to get in touch with her, okay? Do you understand that, sir?
Yes.
All right, so 7,500 with the level 2 GPS. Okay, Erin Emmerling,
No problem, Your Honor.
all right, ma'am, you are before the court. Count one is possession of heroin, and the court does find probable cause. Does anyone wish to be heard?
Judge, as far as bond at this point, she has advised she would not be able to make that $1,000 bond as it sits. She's been in South Florida for 5 years. Right now is not working, but has a roommate trying her best to make rent, but she doesn't have any money in the bank. I don't believe she has significant priors. I would ask the court to consider ROR on this nonviolent third degree.
One moment, Your Honor. Your Honor, the state would be requesting, or I have no objection to pretrial with random testing. Ms. Emmerling just got off probation before Judge Usan last October on 2 separate cases, one for possession of heroin, the other for, looks like felony prostitution.
Ms. Emmerling, I am going to release you to pretrial supervision, and that's going to include random drug testing.
Okay.
The deputy is giving you that information. You need to report within 24 hours of your release. Failure to do so will result in a warrant being issued for your arrest.
Yes, ma'am.
All right, good luck.
Thank you.
Robin Sue Brooks. All right, Ms. Brooks, you are before the court. Count one is petty theft. Count two is committing theft and resisting recovery of property. Count three is petty theft, and count four is resisting recovery of property.
Okay.
All right, the court does find probable cause. And here is the bond.
She has been in Broward County for 45 years, is not a flight risk. Currently, she is unemployed with no money in the bank. My information is that she is at large. However, she does have a location where she can receive mail and a phone that she could call in. I was going to ask the court for standard pretrial she could call in. At this point, she has no money to afford bond.
One moment, Judge. Your Honor, the state would be opposing pretrial. Her criminal history, she's already resolved a theft and trespass this year, grand theft in January of this year. She had two more thefts last year, a theft in 2016. She was arrested 3 times last year on capiases for failures to appear in court.
All right, Ms. Brooks, finding probable cause, your bonds are going to remain in place, 750 on 1 and 750 on count 3. Right? Good luck. Tamitha Sue Contreras.
No problem, Your Honor.
Okay. All right, Ms. Contreras, you're before the court. Count 1 is petty theft. Count 2 is neglecting child without great bodily harm. Count 3 is resisting recovery of property while committing a theft. Count 4 is resisting officer without violence. Count 5, driving while license suspended. Count 6, driving in the wrong lane or the wrong side. 7 is failure to wear a safety belt. Count 8 is child restraint, failure to have child restraint. Count 9 is the same thing, and then count 10 is an expired vehicle registration. Counts 6 through 10 are not for magistrate. The court does find probable cause, and I'll hear as to bond.
Your Honor, she is a 30-year resident of Broward County, not currently, wouldn't be considered a flight risk. She does have ties to the community, her family. Currently, she's living with her mother where she pays rent, a minimal rent. Her only income is a disability income. I believe that largely any priors are involving driving offenses, which at this point she has an understanding that that's something she cannot do. She has advised that due to her limited income and the amount of money she would get in the future, but at this point she doesn't have any money in the bank, the disability checks due sometime off. We were going to ask the court for pretrial.
Under state would oppose the pretrial. I'm concerned. I believe the allegations in this case are aggravating. That Ms. Contreras was acting as a getaway driver for her co-defendant while her co-defendant was shoplifting with 2 young children in her vehicle, then driving recklessly through the parking lot to get away from law enforcement to avoid being apprehended. She drove against traffic because the only exit lane was congested. She is repeatedly driven unlawfully on a suspended license. I see multiple DWS habitual offenders in her past. She's a petty theft in 2016, and I see 2 prior failures to appear. I would be requesting a $2,500 bond on count 2 and an order of no contact with either of the juveniles, whose initials are IL and JL. Nothing further, Judge.
I would just like to inquire if those are her children, if we're to order no contact with them, then at what point, I mean, in whose care would they be? Who would be?
No, the probable cause affidavit says that the mother arrived and took
Okay, thank you.
possession of the
I
children.
did not see that.
Okay. All right, so Ms. Contreras, I am going to impose a bond of $1,000 on count 2. The standard bonds on the other counts will remain, and then no contact with the minor children until further order of the court. Do you understand that, ma'am?
So there's no pretrial for me?
No, ma'am, no pretrial for you. Okay?
Okay.
Teofilo Uceda.
Who's approaching, Judge, your name?
Sir, you have an out-of-state felony hold. It's a no bond hold out of Texas. And you will be going to extradition court either Thursday. Extradition court is Tuesday and Thursday. So I'm not sure if you'll make it there for Thursday but if not, it'll be Tuesday or Thursday that you'll be in court, okay? Ricardo Diaz,
Mr. Diaz, Ricardo Diaz? Donna?
Mr. Diaz, you also have an out-of-state felony hold out of the state of Kansas, and you will be going to extradition court shortly, okay? Deandra Cheney,
Mr. Cheney's approaching.
Mr. Cheney, you're before the court. Count one is possession of cannabis 20 grams or less, and then count two is an out-of-state felony hold. That is a no bond hold. It's a hold out of the state of Ohio. The court does find probable cause. At this time, I don't know. He's already posted the bond? Okay, all right, so then he has a no bond hold on count two, and you'll be before the extradition judge shortly. Carlos Tamayo,
Judge, Mr. Tamayo is here present, and he advises he has private counsel. Jonathan Friedman, I don't know if my colleague had an opportunity to call Mr. Friedman.
okay. Mr. Jason. Oh, okay.
Mr. Friedman, you said?
Jonathan Friedman?
Jonathan. Right, Sue? Jonathan Friedman? Yes.
All right, so we'll recall Mr. Tamayo. We'll see if we can get in touch with his attorney. Thank you. Hernan Navas?
Mr. Navas is approaching, Judge. In the wheelchair. He's coming up, Judge.
Okay. All right, Mr. Navas, you are before the court. Count one is contempt of court on a violation of injunction. Count two is violation of pretrial release for domestic violence. Count three is resisting officer without violence. And count four is possession of a controlled substance without a prescription. The court does find probable cause, and I'll hear from the attorneys as to bond.
Julie Chase with the Public Defender's Office regarding a client in magistrate court.
Your Honor, I'm going to be requesting bonds in the following amounts. $15,000 on count one and count two. Pretrial release with a GPS monitor. No victim contact. I'm asking for these bonds and release conditions because frankly, at this point, I don't know that there are any other way to get Mr. Navas to comply with court's orders to stay away from this victim. I know he's before you in a wheelchair, but according to this probable cause affidavit, he had no problem walking up to the victim's property, and clearly with the intent or knowledge that he knew he wasn't supposed to be doing what he was doing because he moved the camera that they had on their door so it wouldn't film him going to the property. What's most alarming about these allegations is, Your Honor, is Mr. Navas currently has charges pending, 2 counts of violation of domestic violence injunction against the same alleged victim.
Yeah, he just got
He was arrested
got arrested and
March 22nd of this year.
So I'll just, I let
Judge Colra, on one count, gave him a $1,500 bond. He posted bond and was released Saturday, April 20th. It appears he went right to this person's home upon his release from jail, because the first incident that was captured on tape occurred on April 20th at approximately 11:15 in the evening. The second incident was on April 21st at approximately 9 in the morning.
Okay.
Judge, Mr. Navas is 60 years old. He is on disability. He has physical ailments. He gets approximately $900 per month. Judge, right now, from what he's advised me, the $30,000 is something that he does not have, nor can anyone post that monetary bond. So he's asking to be released on pretrial.
All right, pretrial will be, request for pretrial will be denied. Mr. Navas, I am going to impose a bond of $25,000 on each count, 1 and 2, and that is also going to include GPS.
And Judge, would you sign a photo order?
I will sign a photo order, and there is an injunction in place that is still in place, but I will remind Mr. Navas that he has to have no contact with this victim in this matter. No phone calls, no text messages, no social media, no asking anyone to make a phone call for you to this victim. You have to stay away. There's an injunction in place, it's court ordered, and you have to abide by the court order. Okay.
What level is that, Your Honor, the GPS?
2.
Okay.
Richard Ogle?
Conti, Your Honor.
Mr. Ogle, there are 2 misdemeanor capious matters, possession, on charges of possession of cannabis and trespassing. You, okay? All right. So, Mr. Ogle, I'm learning that when this capious was issued on April 3rd, that you were in custody.
Yes.
All right, so, and then you have been sentenced on other charges,
Yes, ma'am.
and, until, when he's in custody until when? Until June?
June.
Okay. All right, so Mr. Ogle, as to these 2 charges, what do you wish to do?
I'd like to resolve in a day if I could.
All right, does the state have an offer for Mr. Ogle?
One moment, Judge. Yeah, withhold court cost on the cannabis, adjudication time served on the trespass.
All right, Mr. Ogle, did you hear that?
Yes, ma'am.
On the possession of cannabis charge, the offer is withhold adjudication and court costs. On the on the trespassing charge, the offer is adjudication and time served.
Yes, ma'am.
So do you wish to accept those offers to resolve this case today?
Yes, ma'am.
All right, Mr. Ogle, please raise your right hand as best you can. Do you swear or affirm to tell the truth?
Yes, ma'am.
You can put your hand down. And Mr. Ogle, do you need any more time to speak with an attorney?
No, ma'am.
Are you under the influence of drugs or alcohol?
No, ma'am.
Have you ever been treated for a mental or emotional illness?
No, ma'am.
You understand you do have the right to go to trial, but by taking a plea today, you're giving up that right.
Yes, ma'am.
And do you understand that if you're not a U.S. citizen, by taking a plea, it could subject you to deportation or immigration changes?
Yes, ma'am.
All right. What plea do you wish to enter, Mr. Ogle? Guilty or no contest?
No contest.
I accept your no contest plea, find that it's freely and voluntarily given. Your sentence, sir, as to the possession charge is withhold adjudication and court costs. As to the trespass, it's adjudication and time served. Good luck, sir.
Thank you, ma'am.
You're welcome. Marlon Silva.
He's approaching, Judge.
Okay. All right, Mr. Silva, you are before the court for a traffic KPS matter. That was issued on February 25th of this year. What does Mr. Silva wish to do?
Judge, in speaking with Mr. Silva earlier today, he wishes to resolve this matter today.
All right, state you have an offer.
Yes, Judge, adjudication time served.
Rosemary Henley.
Judge, he wishes to accept the state's offer.
All right, Mr. Silva, as best you can, raise your right hand, sir. Do you swear or affirm to tell the truth?
Yes.
All right, sir. You can put your hand down. Do you need any more time to speak with your attorney?
No, ma'am.
And do you understand everything that's going on here today?
Yes.
Are you under the influence of drugs or alcohol?
No, ma'am.
And you understand that you have a right to go to trial, but by taking a plea today, you're giving up that right?
Yes.
Have you ever been treated for mental or emotional illness?
No, ma'am.
And do you understand that if you're not a U.S. citizen, by taking a plea today, it could subject you to deportation or immigration changes?
Yes.
What plea do you wish to enter, Mr. Silva?
No contest.
All right, I accept your no contest plea. Find that it's freely and voluntarily given, and your sentence, sir, is adjudication and time served. Good luck. Michael Manuel.
Mr. Emmanuel is present here at Maine. Come on up, sir.
Mr. Manuel, you're before the court on a traffic KPS matter. It is for driving while license suspended. It's a charge. It is a KPS from March 27th of 2018. So the court does find probable cause. What does Mr. Manuel wish to do?
Judge, in speaking with Mr. Emmanuel, we're going to be requesting an RO on his behalf. My understanding, Judge, he was going through a lot. He unfortunately was evicted, and now he's homeless. He's 26 years old, been living here his whole entire life. Right now, from what he advised me, he just basically recently went to DMV to find out how to go about getting his license valid. There were some outstanding tickets, so he's trying to raise money right now. He's going a lot with his family. He informed me his mom's in the hospital, so right now financially they can't post a bond. So Judge, and most importantly, he advised me he has a clean record. So I'm going to ask Judge to consider releasing Mr. Emmanuel ROR in this driving while license suspended.
Okay.
And one moment, Your Honor. Your Honor, since it looks like he just picked up another DWS that is now pending in West Satellite, and that was one moment. About 10 days ago, he got the ticket. This would, let's see. This would not be the first time his license has been suspended for failing to appear in court. And I understand he was going through some hardships, but Your Honor, that was from over a year ago. At any time in the past year, he could have filed a request with the clerk's office in West Satellite to get a new court date, but he hasn't. I'd ask that the bond be kept in place.
All right. I will release Mr. Manuel to standard pretrial supervision. Sir, you if you have some traffic issues that need to be resolved, you need to make sure that you get them resolved and try and work out something to get your license in order. Do you understand that, sir?
Yes, ma'am.
So the attorney's giving you that information. You need to report to pretrial supervision within 24 hours of your release. Failure to do so, a warrant will be issued for your arrest. All right, good luck, sir. Aaron Williams. Okay. Yes. Yes. All right, can we recall Mr. Carlos Tamayo?
Judge, he's here.
Okay, yes.
Your Honor.
Judge, I contacted Mr. Friedman,
Yes.
who advised he had represented Mr. Tamayo in the past.
Right.
He hasn't been contacted, hired, or retained in this matter.
Okay.
So unless that occurs, he wasn't gonna be coming or participating.
All right, so Mr. Tamayo, you just gotta understand that, because an attorney represented you on something else doesn't mean that, they are representing you until you've retained them for a new case. So we've contacted Mr. Friedman, and he said he has not been retained as far as this case is concerned.
Yes, Your Honor.
So have you spoken to the attorney from the Public Defender's Office?
No, Your Honor.
All right, so do you now need time to speak with them, Mr. Romero?
Yes, Your Honor.
Okay.
Yes, sir.
All right, so when you're ready, let me know. All right, Kinnear Thompson.
Mr. Thompson, come up.
All right, Mr. Thompson, you are before the court for an add charge of resisting officer with violence. This is charge number 7. Is Mr. Thompson being held on?
Yes,
I'm
Judge, he's
asking
been
for
in, I believe, over
$1,000
30
bond on
days.
resisting with violence.
Yes, no.
He's got a total of $11,000 worth of bond on a burglary of a conveyance and resisting without violence.
Okay,
$1,000 is reasonable, Judge.
all right, so I'll impose $1,000 bond on this charge. All right, Brandon Neely.
Mr. Neely, come on up, please.
And Judge, just as to probable cause for count 4,
On Mr. Neely?
yes.
Yeah, okay.
I may not have a completed PC, but based on what's in front of me that I'm looking at, I don't see anything indicating
There is a,
would be required.
there
for
is
that.
is it this one? There is a second
I may
PC
not
up there.
have that one then.
Should be an Odyssey.
It is, I think I checked and
Yeah, 'cause, this is, it's a PC that's dated December 27th
is there a
of
case
2000.
number for that or?
19,
Oops, hold on. Okay,
28, 37, CF10A.
it's logged out. I'm sorry, could you please repeat that? I apologize.
Sorry, 19,
Okay,
28, 37, CF10A.
all right, Mr. Neely, you are before the court. Count 1 is grand theft auto. Count 2 is false ID given to a law enforcement officer. Count 3 is driving while license suspended. Count 4 is failure to register as required. Count 5 is an out-of-county felony hold. That is a no bond hold and not for magistrate. And count 6 is a felony violation of probation, and that too is a no bond hold. The court does find probable cause. And I'll hear as to bond.
Your Honor, the state would be requesting a $10,000 bond on count 4, pretrial release with a GPS monitor. I have great concern about Mr. Neely's future appearance in court. Also, I have concerns to the safety of the community, noting what he's on probation for out of Dade County and that there already was a hold for him before any of these incidents. Just the nature of the allegations on count 4 that law enforcement was not aware of where he was located, which is the whole purpose of the registration laws. And then in the immediate allegations before the court, when confronted in possession and operating a stolen vehicle, he gave law enforcement a fake name.
Judge, I do realize he's being held no bond on count 5 and 6. However, from what he advised me, he works when he can at a labor pool, so financial resources are quite limited. Considering as a no bond hold, I'm going to be requesting $1,000 bond on count 4 and an ROR on counts 2 and 3, which are the misdemeanor offenses.
All right. As to count 4, I am going to impose a $3,500 bond. And the bonds on counts 1, 2, 3, which will remain. Diedrich McDowell. Mr. McDowell, you're before the court. Count 1 is robbery with a firearm, and count 2 is resisting officer without violence. Oh, this is the co-defendant to the case?
Yes, Judge.
All right, the court does find probable cause.
And, Your Honor, the state would be seeking a no bond hold on count 1 upon a finding of proof evident or presumption great. The allegations and evidence would support the premise that Mr. McDowell was a principal to the robbery, acting as a getaway driver. He drove Mr. Dean to the location. Upon Mr. Dean exiting the Walgreens after committing the robbery, Mr. McDowell drove in his direction to pick him up. When law enforcement went to make arrest, Mr. McDowell fled from the scene, leaving his car behind. It would also note, post Miranda, Mr. McDowell gave a video recorded statement. He admitted to being the driver during the Walgreens robbery and fleeing from law enforcement.
Okay.
Judge, I would just ask the court to deny the state's request to find proof evident presumption great, holding Mr. McDowell no bond. In review, what we have here is a probable cause report. It's constructed for the purpose of probable cause. And it's about 2 pages. I don't believe that it would rise to the standard of proof evident presumption great, which is the highest standard that we have.
All right, the allegations that we have here are that the law enforcement was in close proximity. These arrests were made pretty quickly right after the incident. And the affidavit is a report from the officer as to what he observed on this day. So the court does make a preliminary finding of proof evident presumption great. This is without prejudice for the defendant to have a bond hearing based on State v. Author. And Mr. McDowell will be held no bond on count 1. Does anyone wish to be heard as to
Nothing from the state.
anything
Judge.
else?
No, Judge.
Okay. All right, good luck, sir. Henry Harp.
Mr. Hart, come on up. Judge, Mr. Harp is approaching, and he declined the services of public defender. Judge, Mr. Harp just changed his mind right now. He wishes to apply for public defender. So
All right, if you
we
need a
can put
few
on
moments,
recall.
I'll recall. Michael Rostock.
Mr. Rostock is approaching, Judge.
All right, sir, you are before the court. Count one is possession of alprazolam, and count two is possession of drug paraphernalia, and the court does find probable cause.
Your Honor, he's currently on free trial for possession of fentanyl. He's placed on free trial on February 22nd of this year. We're asking that you revoke his free trial in case number 19002479CF10A.
Is that a filed case?
Judge.
Oh. I'm sorry, Mr. Linder, you said no?
No, it has not been filed.
Okay, all right.
Judge, I heard that the court inquired if the case was filed or not filed. I didn't hear the answer.
No,
If it was filed or not.
it's not
It's
been filed.
Judge, as you can see, he picked up a new charge, and it's a drug offense. I'm going to be asking at this time if the court would consider raising the level of supervision. I believe he's out on standard pretrial release. I'd be asking for the court to consider releasing Mr. Rostock on level 2. He does have a place to live. He lives with his family in Plantation. Right now, he works when he can in roofing. He's 28 years old, but Judge, I'm going to be asking for a higher form of supervision considering the new law offense.
Your Honor, I'd ask that the court, and I understand that the court takes no action on the pending case because it hasn't been filed, but as far as what's an appropriate release, clearly pretrial's not working or we wouldn't be here today on a new law offense for essentially a drug-related. I'd ask the court keep the bond in place. He's already had last year a grand theft, a separate case with possession of cocaine, fentanyl, criminal mischief 2017. I mean, it looks like the court was taking a chance giving him pretrial earlier this year, and now within 2 months he's back before the court again.
As to the case number 19002479CF10A, the court will take no action on the pretrial. As to the new arrest, the bond of $1,000 is going to remain in place. You need to grow longer arms.
Your Honor?
Yes.
If we could check on Carlos Tamayo, just to
Tamayo.
see if we can proceed. It's the last DV case.
Give me one moment, Mr. Leonard. I've been here at the podium.
As soon as you're ready.
We were just
Unless
checking to
you
see
need-
if he was going to be represented by Mr. Freeman.
No, he's not. We did that. He's not represented by Mr. Friedman.
Is he still there?
Yes, and then they needed a little bit more time to speak with the attorneys. Does Mr. Romero, do you need the court to take a short recess?
No, just, as soon as you go to a different gentleman at a different facility, I can talk to Mr. Tamayo, and then I'll be ready.
All right, so let's do this. Is in North Broward, do you have anyone else that needs to be addressed? North Broward? No, I'm just checking to see if is there anyone at North Broward that still needs to be addressed? All right, hearing nothing. Conti? Everybody? And Paul Ryan is definitely no one there. All right. All right, then, Mr. Romero, we'll take a brief recess so you can catch up because all the other facilities are,
Judge, I'm ready.
all right. Are you ready with Mr. Tamayo?
I am, Judge.
All right. All right, Mr. Tamayo, you're before the court. Count one is battery causing bodily harm. Count two is throwing a missile into a vehicle. Count three is resisting officer without violence. And the court does find probable cause.
Your Honor, he's currently on pretrial for possession of cannabis in case number 173621 MM40A. We're asking that you revoke his pretrial in that case.
Okay. When was he placed on pretrial?
October 23rd, 2018 by his division judge,
Okay,
Judge Zeller.
all right. All right, the court does find probable cause, and I hear from the parties as to.
Just looking up something on a felony case, Your Honor. I think he's on probation.
173621
DOC.
MM40A. You're welcome.
Let's see. Wait, what? Is that from the felon? Because I'm showing that he's on probation on a felony case.
It's a 1701-4309 CF108.
I don't know. 14309, yeah. He's on probation on that? Yeah. Okay.
You're welcome.
Your Honor, I'm going to be requesting a $5,000 bond on count one, a $5,000 bond on count two, no victim contact. The reason being is he's on probation before Judge Allspector right now for resisting with violence, battery on a law enforcement officer, and domestic violence battery. It would appear after he was placed on probation for a year in September of last year, he was arrested for a new domestic violence battery in October of last year against a different alleged victim, and that was dropped.
Okay. Mr. Romero?
Judge, considering what the state pointed out at this time, defense has nothing to add.
All right.
We're just requesting a photo order.
All right, on case number 17003621 MM40A, the court is granting pretrial's request to revoke pretrial supervision. And the court is going to impose a $1,000 bond. As to the new arrest, I am going to, I find probable cause, I am going to impose $5,000 on counts 1 and 2. And no victim contact. Look, sir. Antonio Munoz.
He's approaching, Judge.
Sir, you are before the court, possession with intent to sell, deliver, or manufacture heroin, and count 2 is possession of drug paraphernalia. And the court does find probable cause.
Judge, nothing to add by the defense at this time.
All right. All right, sir, your bond is $2,500. Good luck.
I'll call Steve right afterwards, okay?
Eddie,
I'll call him.
Eddie Butler.
Mr. Butler, come on up, please. He's approaching, Judge.
All right, Mr. Butler, you are before the court for 1 count of grand theft, and the court does find probable cause.
Judge, in speaking Mr. Butler, we're going to be requesting that the court consider releasing Mr. Butler on pretrial release. He's 44 years old, been living in our community his whole entire life. Right now, my understanding, he's going through severe medical issues. He was hospitalized for about 3 weeks, and now, unfortunately, he's homeless. He does have a mailing address where he can receive future court correspondence, so he can make sure he's not going to miss a court date. I believe this happened at a Home Depot in which the merchandise was recovered. It's a nonviolent offense. So I'm going to be asking the court to consider releasing Mr. Butler on pretrial release.
I have no objection to that, Your Honor. Just ask for an order of no return to this Home Depot.
All right, Mr. Butler, you'll be released to pretrial supervision. The attorney is handing you that information. You need to report within 24 hours. If you don't report, a warrant will be issued for your arrest. And also, sir, no return to this Home Depot.
Yes. If you get out today early enough, you go there. It's across the street. If they're closed, then you go there tomorrow morning, all right? Okay. Just follow the map. It's across the street from the main jail. Okay. Crossing 3rd Avenue. Good luck, sir. Second.
All right, Malachi Deloche.
Mr. Deloche is here present, Judge at Maine. He's approaching. Come on up, sir.
All right, sir, you're before the court for grand theft auto, and the court does find probable cause.
Judge, in speaking with Mr. Deloche earlier today, he gave me phone numbers of several family members. I intend on contacting them as soon as I get out of here, and he believes that they could post his monetary bond, Judge.
All right, your bond is $1,000, sir.
All right, I'll contact your whole family as soon as I get out of here.
Malik
I
Jones.
will. No problem, I will. Mr. Jones, come on up.
All right, Mr. Jones, you are before the court. Count 1 is grand theft auto. Count 2 is possession of cannabis 20 grams or less. Count 3 and 4 are felony violation of probation. Those are no bond holds. Counts 5, 6, and 7 are out-of-county felony holds. And those,
Let's see.
count 5 is no bond, not for magistrate. Count 6 and 7 do have bonds attached to them, $2,000 and $250. These holds are out of Hillsborough County. The court does find probable cause. And your bond on count 1 is $1,000. Quandarius Hammond.
He's approaching, Judge.
All right, sir, you are before the court for grand theft auto, count 1. Count 2 is possession of cocaine, and count 3 is resisting officer without violence, and the court does find probable cause.
Judge and speaking, Mr. Hammond, at this time, nothing to add. I'm going to be contacting his girlfriend to post his monetary bond.
All right. State, do you wish to be heard?
No, Judge.
All right, so Mr. Hammond, the standard bonds are in place. Sheldon Schwartz.
Mr. Schwartz is approaching, Judge. He has private counsel. I believe my colleague spoke to him.
I did reach out and speak to the attorney. He's indicated that he's technically not on the case. However, he assumes that he will be, but he did say we can call him and he feels it's inappropriate at this time since he's going to represent him, just not technically.
Okay. All right, Mr. Schwartz, because you had an attorney representing you on a case before, doesn't mean that they represent you forever. I mean, unless you have them on retainer for representing you for forever. So we did make a phone call, and the attorney has not been retained on this case. So he's not your attorney as of this moment, okay?
Okay.
All right, it doesn't mean that, you can't go and hire him, but as of this, so he's not gonna come to court today.
Okay.
All right, so your options are you can proceed on your own, or you can speak with the attorneys from the public defender's office. It's your choice.
I'll proceed.
All right. So you are before the court today for battery on a person 65 or older, and the court does find probable cause. So, sir, now we're going to talk about setting a bond for you. So if there's anything that you wish to say in regards to setting your bond, not about the case that is before the court right now, but just about the bond, I will hear from you.
I'm a nice guy. ROR sounds really good.
Okay. All right. State.
Your Honor, I was going to be requesting a $500 bond and a no contact order. My concern is it appears that the two parties are neighbors, that they live directly next to one another. And really, my greatest concern is that there's just no contact, whether it be physical, verbal, no communication, no contact between the two parties.
All right, so 500 is what you're requesting?
Yes, Judge.
And no contact? All right, so Mr. Schwartz, you are going to have to stay away from your neighbor.
I tried. 5 years I've tried.
Well, you're gonna have to try harder, because now a violation of that stay away order will mean that you will be before me again. So
I don't want to. I don't want to see you again.
I'm sure you don't. So I am going to impose a bond of $500, sir, and I'm gonna tell you that you need to stay away. That, no talking, no calling, no other person talking on your behalf, no social media, no emails, nothing. Do you understand that?
Yes, I do. In my defense, can I say something?
No, don't talk about your case, because
okay.
you're gonna talk to your attorney and hire your attorney, and then you can tell him about your defense, okay? All right, sir, good luck. 500. Thank you. Jason Williams.
Mr. Williams, come on up. Judge, Mr. Williams advises that he believes his family hired a private attorney for him. We've been trying to contact his mother. I believe we also got in touch with, or trying to get in touch with his stepfather, but no answer. No one's answering, Judge, so I just wanted to let you know that.
All right, Mr. Williams, I guess efforts have been made to see who your private attorney is. We don't know. And so at this point in time, we're going to proceed. Okay?
Yes, ma'am.
All right, you are before the court today for count 1 is a possession of a weapon or ammo by a convicted felon. Count two is possession with intent to sell, deliver cocaine. Count 3 is possession with intent to sell, deliver heroin. Counts 4 and 5 are out-of-county felony holds, and those are no bond holds and not for magistrate. These are holds out of Miami-Dade. Okay? So the court does find probable cause, and I will hear as to bond on count 1.
Your Honor, the state is going to be requesting a $10,000 bond on count 1. I'm also going to be requesting a GPS monitor level 2. Your Honor, I can advise the court, I spoke to Detective Willis from the Broward County Sheriff's Office yesterday. He authored the probable cause affidavit. Detective Willis has great concerns for the safety of the community with respect to Mr. Williams. I share those concerns. And this isn't just based on the allegations in this case, where again he was found in possession of a firearm. It is Detective Willis notes on the top of the probable cause affidavit, and I verified this through the Florida Department of Law Enforcement. Mr. Williams is a registered gang member. He's wanted out of Dade County at the time of this incident for a firearm offense, specifically possession of firearm by convicted felon and carrying concealed firearm. In 2014, out of Broward, he was convicted of possession of a firearm by a convicted felon and was sentenced to a year and 11 months in Florida State Prison. He was released from state prison April 9th, 2016. In 2009, he was convicted of burglary of an occupied dwelling and trafficking cannabis and sentenced to 3 years state prison. Your Honor, I am aware that Mr. Williams has no bond holds out of Dade County. However, that is a separate matter than the Broward offenses, and at some point, should he be eligible for release, I believe it is necessary for the safety of our community that he have the bond that I'm requesting, but also be supervised with the GPS monitor.
All right. Mr. Williams, is there anything you wish to say, not about the case or the arrest, but about setting your bond?
No, ma'am.
All right. So I am going to impose on count 1 a $10,000 bond. That's going to be with a GPS monitor. And counts 2 and 3 will have the standard bonds, and then 4 and 5 are no bond holds out of the holds from Dade County. Okay?
Yes, ma'am.
I'm sorry. GPS, yes. Yes. Okay, sir, good luck. Jeremy Smith.
Mr. Smith is here at main judge approaching. He declined the service of public defender.
Mr. Smith, you are before the court. Count 1 is possession with intent to sell, deliver, or manufacture cannabis. And then count 2 is a felony violation of probation. That's with a no bond hold. You will be before your felony judge tomorrow at 8:30. The court does find probable cause, and then your bond on count 1 is $1,000. Good luck, sir. Michael Diaz.
Mr. Diaz is approaching, Judge.
Mr. Diaz, you are before the court for count 1, possession of controlled substance without prescription. Count 2 is resisting officer without violence. Count 3 is operating motor vehicle with the license expired. Count 4 is petty theft. Count 5 is a traffic capias. And count 6 is larceny from a person 65 or older. Okay, the court does find probable cause.
Judge, we're going to be requesting that the court consider releasing Mr. Diaz on pre-trial release. Mr. Diaz has been living here his whole entire life. He's 40 years old. 45. Oh, 45. I apologize, Judge. He's on disability. He gets approximately $790 per month. Now, he lives in Lauderhill with his girlfriend and his son. His girlfriend right now is in between jobs. She was working as a bartender, and now she's looking for employment. And count 5, in reference to the miscord on the expired DL, my understanding in speaking to him He didn't get notice, and that's why he didn't go to court. Also, he's quite surprised when I informed him as far as one of the charges, specifically count 3, which says operating a motor vehicle with a license expired. From what he advised me, he actually went out and got a valid license. He doesn't know why the officer wrote him a citation or arrested him for operating a motor vehicle with a license expired. He even says it's here in property, his valid driver's license. But Judge, considering these are nonviolent offenses, I'm asking the court at this time to consider releasing Mr. Diaz on pretrial release.
Well, first of all, and it's really probably the most minor part of this, his license is suspended right now. But that's really not even what I want to focus on. I'm requesting that the court set the bond on count 6 at $10,000, Your Honor. I believe that is more appropriate considering the amount of money he stole from the victim in this matter. It would appear, he was taking advantage of an elderly person, noting that he's, in the new offense, he's back before the court on another theft. I would also note he currently has a warrant out of the state of Pennsylvania, Philadelphia, from 2017 on a larceny. He has been to state prison in Florida in the past for grand theft, burglary of a dwelling, sale delivery of cocaine, getting hits out of, in addition to the pending case or the warrant out of Pennsylvania, his history out of Florida, he has a reckless driving out of South Carolina in 2016, and in the past, a woman in Broward has felt it necessary to seek an injunction order of protection against Mr. Diaz.
All right. The court does have great concern for the community. The allegations as far as the larceny is that Mr. Diaz as an employer of Atlantic Construction went and received a check for $9,000 of which was partial payment for an $11,000 job. And the allegations are that he told this person to leave it blank and then later cash the check. And so the court this morning does find that there is a concern for the community. So as to count 1, the bond is $1,000. Counts 2 and 3 and 4. The court will not impose a bond. Then count 5, there's a $250 bond that's in place. And then as to count 6, the court will increase the bond to $10,000. And should Mr. Diaz post the bond, he will be on level 2 GPS.
Your Honor, just in abundance of caution, I'd ask for no contact with Diane Sullivan and Patricia Colson.
No contact with these alleged victims, and no return also to this address.
Your Honor, the pretrial is for larceny case?
Yes, yes, for the larceny. Yes. Thank you. All right, William Bacon.
Mr. Bacon is approaching, Judge. Mr. Bacon declined the services of public defender, Judge.
Judge, I was advised he was going to retain David Frankel. I reached out to his office and they asked if we could reset it for the afternoon so he could.
All right, so Mr. Bacon, your attorney is asking for this matter to be reset on the afternoon docket, so you'll be back this afternoon. Okay?
Thank you, ma'am.
All right. Anthony Tropiano.
Judge, he bonded.
All right, thank you.
Did we do Mr. Monroe? Because that was, someone had signed in for Monroe, but we called it and they had left.
I'm sorry, what was that? All right, is somebody, okay?
It's on page 22.
All right, James Monroe.
He's here present. Judge, come on up, Mr. Monroe.
All right, Mr. Monroe is here for grand theft. The court does find probable cause.
Judge, I'm going to be asking the court to consider releasing Mr. Monroe, ROR. My understanding is this is his first contact with the criminal justice system. He's 18 years old. He's been here his whole entire life. He was attending school at Piper High School, where he was having problems with one class, so then he transferred to Whittam Rogers in order to graduate on time. However, when he was attending Piper High School, Judge, he was on the ROTC since his freshman year, and he was playing basketball. From what he advised me, he's doing quite well in that sport, in which he's actually received, I believe, a scholarship opportunity to attend Bethune-Cookman. He is set to graduate Whittam Rogers. He has a 2.5 GPA this June. He is living in Sunrise with his mother. His mother works, I believe, for the transit. Judge, if the state can confirm this is his first time being arrested in his life, I'm going to be asking the court to consider releasing Mr. Monroe straight ROR on this non-violent offense, Judge.
And Judge, I just wanted to add, I'm sorry, that his father was previously here, but had to leave due to paying for the parking meter.
Okay.
He did advise that Mr. Monroe can reside with him. He would have no problem with, as he is, in taking care of things and control of the situation. But he did want to let you know he was here on his behalf.
Okay.
Your Honor, I don't have a problem with pretrial. I am a little concerned that the allegations are just over a week period, on 7 occasions, he stole $2,170 in cash from his employer, looks like straight from the registers. And only $130 was recovered.
All right. I am going to release Mr. Monroe to pretrial supervision.
I'll listen to the judge. Give the instructions.
All right, Mr. Monroe, the information that the attorney just handed to you gives you the address where you need to report to within 24 hours of your release.
Okay.
If you do not report, a warrant will be issued for your arrest. Do you understand that, sir?
Yes, ma'am.
All right, so you need to make sure that you follow through with that, and they will give you further instructions. Good luck.
Thank you.
You're welcome. Henry Harp, what were we doing?
We're ready.
Oh.
Mr. Harper,
Good morning, Mr. Harp. You are before the court for count 1 is grand theft of a firearm. Count 2 is carrying a concealed firearm, and count 3 is possession of weapon or ammo by a convicted felon. The court does find probable cause. Anyone wish to be heard as to Mr. Harp?
Yes, Your Honor. I'm going to be requesting a $7,500 bond on count 3. He just was released from state prison September 22nd of 2017. He's gone to state prison for the following offenses: Out of Broward, domestic violence battery by strangulation. There were also charges of battery and violation of a domestic violence injunction. And out of Martin County, burglary of an occupied dwelling and grand theft.
Okay.
Judge, right now, Mr. Harp is going through a tough financial time. He's homeless, and he's looking for work. He does have a mailing address where he can get future court correspondence. From what he advised me, he has no money in the bank and no property. He's been here his whole life. I'm going to be requesting on count 3, the court considers setting a bond of $3,500, along with counts 1 and 2. That would be $5,500 bond that this defense is requesting.
I am a little curious, Your Honor. Being represented, Mr. Harp is homeless. He was found sleeping in the driver's seat of a 2019 Volvo.
And Judge, she owns no vehicle. So as far as with DMV, there wouldn't be anything with his.
All right,
And Your Honor, just to say, my point is.
Wait, hold on. Oh, sorry, Mr. Lynn.
I wasn't trying to suggest he purchased the vehicle. Either he rented it, or he knows someone that owns a 2019 vehicle that feels comfortable enough with him to let him take their 2000 new vehicle. Point is I am not 100% sold that his financial condition is what he's representing it to be.
all right, I am going to impose a bond. Counts 1 and 2 will remain standard bonds, so $1,000 on each count. Count 3, it'll be $7,500. Good luck, sir. John Charles Tyre.
Was he on medical recent?
He was. I think we found probable cause, and he's to come back for bond, I think.
You did, Judge, yes.
All right, so he's not here today?
He was on page 26. We're looking right now, Judge.
Okay.
Medical reset, Judge.
All right, and then how about Jonathan McGriff?
He's approaching, Judge.
All right, Mr. McGriff, you are before good morning. You're before the court for driving with a suspended or revoked license, count 1. And count 2 is a felony violation of probation. That's a no bond hold. And you will be before your division judge tomorrow at 8:30. The court does find probable cause. Your bond on count 1 is $25. Good luck, sir. Have we covered everyone?
I think so.
All right, I'll see everyone this afternoon.
Sounds good.